Ohio becomes the latest state to adopt permitless carry, and an interview with the lawyer responsible for wiping out stun gun bans. That and more on this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can pick up a membership today if you want to support the work that we're doing. We're 100% reader funded at this point, which means we wouldn't exist without our members. And if you do pick up a membership, you'll get exclusive access to dozens of exclusive pieces on all kinds of firearms-related content, whether it's exclusive news reports or exclusive analysis pieces that you can't find anywhere else. You'll also get early access to this podcast and the opportunity to appear on the show in one of our member segments, which we actually have this week. Looking forward to talking to one of our members at the end of the show, so make sure you stick around for that. And you'll be helping deliver informed, independent firearms journalism that just there isn't enough of in this world, I think. Anyway, this week we have a special guest, Alan Beck, who is a lawyer, a firearms rights lawyer, who has done a number of notable cases, but for the purpose of our show today, the most notable of which is his litigation on stun guns. And we saw this week Rhode Island's statewide ban on stun guns and tasers struck down, and it was the last total ban, statewide ban on stun guns out there. This is a pretty momentous achievement. And Alan, why don't you start by telling the audience just a little bit more about yourself?
Thank you for having me, Stephen. I'm a solo practitioner based out of San Diego, California. I did all these stun gun cases with attorney Stephen Stabilia, who's based out of Mississippi. I've been an attorney for 12 years, and for 11 of those, I've been, at least in part, litigating Second Amendment cases, and I do a lot of just various lawsuits against the government under different issues, according to the Administrative Procedure Act, Freedom of Information Act. But the thing I like most is under the Civil Rights Act, I've litigated a lot of cases under something called 42 U.S.C. 1983. And that's the vehicle by which we litigated these stun gun cases and the vast majority of other firearms cases.
Yeah, so you've done quite a lot of gun cases and gun rights cases, Second Amendment cases, and but of course we want to focus a little bit, at least initially here, on your work with stun gun bans, because that actually, at least in my estimation, I think any fair observer's estimation, has been the practical legacy to this point of the Heller decision, the Heller and McDonald decisions, because it's really the stun gun bans are the only policy you've seen systematically dismantled in the wake of those two major Second Amendment decisions, right? Is that fair to say? I mean, how many cases have you done?
Say, yes.
How many cases have you done? How many laws have you had overturned at this point?
For stun guns, we've overturned 4 statewide laws. That's New Jersey, New York, Hawaii, and Rhode Island. And then we've had several municipal city laws that we've overturned. And those, and some of those were done by litigation. Some of those were just simply after we started winning. We sent out pre-trial demand letters. And so that was New Orleans and Annapolis. That's in Maryland and Louisiana, respectively. We actually filed lawsuits. They just threw in the towel shortly afterwards. And then we had Westminster, Maryland, Tacoma, Washington, and Philadelphia. We sent demand letters. Look, we're already winning. Turn in, here's a letter. We're going to file a suit unless you repeal them in those cities. So 5 total. Those 3 cities, they just got rid of their laws after we sent those demand letters. So 4 states and 5 cities.
Right. So this is pretty systematic, the way that you've gone about addressing these bans. And there hasn't been any other sort of policy like that just wiped off the slate here. I mean, obviously Heller was directly about Washington, D.C.'s handgun ban, and then McDonald was directly about Chicago, Illinois' handgun ban, and those were wiped out. But there really weren't a lot of those types of policies out there. They were really outliers. And you just haven't seen that level of systematic change from these landmark Second Amendment rulings, except for these stun gun cases. So how were you able to have that sort of effect? And I mean, what was the mechanism that allowed you to really have success like this?
Well, I had initially studied the issue of tasers about with actually my first case, Baker v. Kealoha, which we filed in 2011. But we just didn't, we decided, and that was a Kerry case, and we were thinking about doing a taser action as well, but just didn't really get a lot of headway. So I'd studied a lot of Eugene Volok's work, and he is the academic that spent quite a bit of time studying why these things are unconstitutional, why stun gun and taser bans don't make sense. And I also, I got quite a bit of advice from attorney George Lyon, who is an attorney out in the District of Columbia. He filed a case called Crystal v. Wright. And, between those, I know both of them personally. And, I'd worked on it. And then after the Jamie Saitano decision, we went and saw that this was a situation that was ripe for litigation. So, and in the Saitano case, what happened is the Massachusetts Supreme Court decided to uphold a ban on stun guns, and they did so based upon the reasoning that stun guns were not around at the founding of our country in 1791. Right. That's just completely against Heller and just the wide body of constitutional jurisprudence, because, obviously, to take that logic, I mean, they didn't have, the internet and, even a lot of modern forms of printing, could arguably be prohibited if you want to take the reasoning that something had been around in 1791 in order to be constitutionally protected under, the First Amendment. And, the Supreme Court expressly stated in Heller that this is not a, just some sort of archaic amendment. I mean, this is something that has modern relevance. And, there's a specific passage that's it's directly on point. And so the Saitano decision, what the Supreme Court did in a 2-page per curiam opinion, that means by the entire court, it was unsigned, and it had to be a unanimous per curiam decision. The court said that, no, you got to go redo it, and look at your reasoning again, because it's not dispositive. Just because something's not around in 1791, that's not dispositive. They're not protected by the Second Amendment. So and then in a concurrence, concurrence is where a judge agrees with the outcome but has his own take on things. Justice Alito wrote a concurrence, I believe, joined by Justice Thomas, where he said, these are absolutely protected, but that concurrence wasn't binding upon the court, just on the lower courts, just the court's per curiam decision, which said, hey, you have to go redo this and redo your legal reasoning. And even though the court could have said, hey, we're redoing it, we're applying, we're upholding this ban based upon legal reasoning you might agree with. I thought that the fact the Supreme Court had pretty strongly indicated that it believes that electric arms, stun guns, and tasers are protected was enough to really take what I'd done back in 2011 and then build upon it significantly in order to start a number of lawsuits.
Yeah. So that 2016 Supreme Court opinion, where there was a unanimous opinion, right, that essentially said Massachusetts Supreme Court was wrong, that modern technology is protected under the Second Amendment, that obviously the case dealt directly with stun guns and tasers. That really was a catalyst for your efforts.
Yes,
Really, it enhanced what you were already doing.
yeah, absolutely. We wouldn't have done this most recent push if not for the Supreme Court's 2016 opinion.
And I think the Rhode Island case in particular, the new one that you just won, the judge there was very critical of Heller, right? He doesn't have a lot of respect for the ruling and it's the logic behind it, but he felt it was necessary to abide by it, probably in part because of this 2016 sort of reaffirmation.
Yeah, I mean, it's, I think the judge really looking at a Hobson's choice. I mean, he could have found a way to uphold the ruling, but then I would have the option of appealing that up to the First Circuit, which is the Court of Appeals in charge of Rhode Island, and then ultimately up to the U.S. Supreme Court. And, with Saitano the way it was, I mean, it's a strong indicator that if the matter got to the Supreme Court on the actual merits, and the Supreme Court was forced to rule on whether explicitly, whether this is constitutional or not, the Supreme Court was going to overturn the stun gun ban. And, that's actually worse. Supreme Court ruling is a lot worse than a trial court ruling if you don't, if you're not in favor of the Second Amendment. So I think the judge wanted to voice displeasure, say that, I think that this issue was poorly decided, but that Heller was poorly decided. But ultimately, he wanted to apply precedent, both because, that's simply what the law is. And the fact is, ultimately, if you write an opinion that's not, does not apply precedent, then you have a very strong chance of being reversed on appeal or elsewise.
Right. And so I guess the really interesting thing to me, at least, about this whole situation with stun guns and how the 2016 Statino, and I always pronounce that wrong. I think it's. I apologize to the plaintiff in that case, but the 2016 unanimous ruling really plays so much of a role here and gives such an example for how other Second Amendment cases or other areas of Second Amendment law can actually, where the Supreme Court can actually have that long-lasting impact. Because you've seen Heller's obviously a landmark decision because it establishes this individual right to keep and bear arms. But as mentioned at the opening of the show, there hasn't been a lot of systematic redoing of the nation's gun laws after Heller to this point. But here is the model of what that might look like if applied to other areas. So you have Heller, and then you have this second ruling in 2016 that's unanimous. Now, it'd probably be hard to get a unanimous ruling like that on more controversial topics of, in these other Second Amendment cases. But, it's an example of the Supreme Court sort of reasserting its initial ruling, telling Massachusetts that its interpretation of Heller was wrong. And then now you've had a lot of lower courts abide by that in these multiple different cases across the country, even if they don't like the Heller decision in the first place. So do you see that what you've done with these stun gun cases as an example for how other areas of Second Amendment case law could go?
I think that this is what we're going to see very soon, and probably by June, with the U.S. Supreme Court ruling in Brune that there's going to be more guidance at the Supreme Court. And, my personal view, to be honest, is it's not going to be as expansive a ruling as we might hope for. And what it's going to do is give more guidance to the lower courts. And there's going to be a similar situation, just like where I had to follow up with a number of lawsuits after the Saitano decision. There's going to be a lot more work to do. But with that guidance that's going to come from the Supreme Court, there's going to be a lot of cases that are going to need to be filed, And I think the important thing is we try and figure out what are winnable cases that are being done within the framework the Supreme Court has given, and push the envelope a little bit, but in a manner that the lower courts are going to be obligated to follow, in light of what guidance were given in June.
Yeah. And it's interesting because I know there was some criticism of your effort to go after these stun gun laws initially. People thought this was a risky move that could backfire, right? If you lost some of these cases, perhaps it would have, set Second Amendment protections back. So what was it in your calculation that made these cases worth trying in the federal courts?
Well, I think there was a number of reasons. I've always felt that, you have to just simply acknowledge that there is a political component to even the judiciary. There's a saying that, if you can't expect it to be seen on the front page of the papers, or if people would get mad by it, there's a good chance the Supreme Court's not going to rule, in a way that's, just completely beyond the scope of what's politically palatable, at least to a segment of society, and with firearms, there's a very heated conversation with in this country, obviously, and that with the stun gun, that I felt that allows the court to rule on what arms are protected by the Second Amendment without delving into the issues of, say, mass shootings or, headline about gun violence, whether they can just simply back up and look at it analytically. Well, this is something that's obviously less dangerous than the handgun issue in Heller. And it definitely is an arm which can be used for self-defense, and there's simply not a lot of crime associated with it. So we can just simply look at this as a legal issue rather than something that has a lot of political baggage associated with it. So because it is a less than lethal weapon, I always felt that this makes for something that allows the courts to simply sort of look at it, a little bit more analytically rather than having to think about it in, with some sort of political component.
Interesting, yeah.
And yeah.
And so obviously now you weren't the lawyer in Sertino, the 2016 case, but I think your theory there probably goes to one of the reasons why that was a unanimous decision, right?
Yeah, I mean, I think, absolutely. I mean, I think we should take a look at the optics of and I myself do not know how to pronounce that last name, so bear with me. Jamie Saitano was a 4'11" homeless woman who had an abusive ex-boyfriend who she had been attacked by in the past. A friend of hers gave her a stun gun for the express purpose of defending herself from her ex-boyfriend. She had, shortly after receiving it, she at one point brandished the stun gun when the ex-boyfriend came by, and he fled. Then shortly thereafter, she was in a parking lot of a grocery store, and the police caught her with it. And it served its a purpose there. No one was harmed, and just the undisputed facts of the case are stun guns are not something that really can be used in the way that they can, that maybe is associated with some other weapons, in terms of crime. So it went before the Supreme Court. I think the optics were really good there. You have the exact type of person that needs a weapon. I mean, in Justice Alito's occurrence, I think he mentions that her domestic abuser was a foot taller than her. I mean, she needed a means of self-defense. She was 4'11", but she needed a means of self-defense in order to protect herself. And I mean, I think it was real. It wasn't something that was so, astroturf. I mean, this is a very real person, a real situation. And I think that played to the outcome of the decision, that all the justices were confronted with a person that was just simply trying to protect themselves, and a nonsensical law was in place that was criminalizing her ability to defend her own life, And so, yeah, I absolutely agree with your statement, Stephen.
And so what's this, the lay of the land now as far as stun gun bans go? Obviously now there aren't any more statewide total bans left, but there are still a couple of cities, and I think Michigan has a permit requirement to buy stun guns, something like that. Where are things at now, and what are you looking forward to, past this Rhode Island case?
Well, there are two major cities that still ban stun guns, and that's in New York City. They have an ordinance which prohibits the possession of stun guns. And then also in Delaware, in Newcastle County, and the city of Wilmington, which is in Newcastle County, has its own independent ordinance that they prohibit the possession of tasers and stun guns. Now, a friend of mine is already litigating a case in New York City. So, I mean, that issue, I at least hope, will shortly be resolved. But Castle County, that's something that needs to be looked at, and hopefully I'll have an opportunity to go there in the near future. For myself, in terms of what I'm doing with my Second Amendment litigation, I've got a number of cases that are, in the works right now. I've obviously have the Young case, which is a challenge to Hawaii's effective ban on handgun carry or firearm carry in total, which is up in front of the U.S. Supreme Court right now. It's being held pending the outcome of the New York case, the Bruin case, which was argued last fall. And I also have I have a number of unfiled cases which are in the works, so maybe we can talk about after they're filed.
Sure. But specifically on stun guns, right? You have a couple more that you're considering.
Well, specifically, I'm considering Castle County.
Yeah.
There's only two places left, major cities.
Yeah.
There might be some small towns or something that I'm unaware of.
Well, I think it's interesting. Yeah, no, that so yeah. I mean, it sounds like there's not that many left out there. There's a couple.
No, there's two major cities.
Yeah. Wow. So I mean, that's pretty remarkable. But it's still interesting to see, because Sertano was at this point, that was 6 years ago, right? And it's still taken all that time to really to get most of these laws off the books. And I do think that, as you mentioned earlier, that is also sort of gives a guide to how perhaps overturning these May issue gun carry laws, how that might actually go in real life. And so that, I think that's an interesting point, is to another way where this stun gun litigation provides an example for other areas of Second Amendment law that people are probably more focused on. But here's something you can look at as, this is what it might actually take in real life, and 6 years and to get through the bulk of these bans, and you still have two major cities that are left to go even now.
Right, and this took me 5 years from the time of filing. I mean, almost immediately after the Sertano came out, I began preparing these cases. And that's just simply the nature of federal court, is that these things take years. Over 5 years to get to this point, and it's people have to understand. I mean, outside of, you get lucky sometimes, they throw in the towel right away, but for the most part, even if the law is on your side, you have to spend several years in the federal courthouse, and you have to go through all sorts of procedural stuff. You have to file a lot of paperwork. You have to do discovery. And, I mean, that's just simply the nature of the beast. So, I mean, it's to a large degree wishful thinking that just overnight Supreme Court's going to pound its gavel and things are going to change. There has to be a lot of just time in the trenches, just digging, and trying to push, through the legislative inertia.
Right. Yeah, absolutely. And I think that's an important thing for people to realize. And what you've done provides a good example of how it works in real life. Another thing that I'm interested in, which is one of the things that I would expect to see if the Supreme Court does strike down may issue permitting for gun, concealed carry in this brewing case out of New York, is not just that you'll have to go after the laws that are in the other 7 states that have may issue, but also that you'll see this tactic of incremental changes, like you saw in DC's with their gun carry law. They had a total ban at one point that got struck down by the federal judge. Then they instituted a may issue law, and that got struck down too. And now they've gone to a shall issue system, but it's one of the stricter shall issue systems in the country in terms of what you actually have to do to get a permit. There's the training requirements higher than most states. It's more expensive. It takes longer, and the permits are for a shorter period of time. Have you seen anything like that come out of these stun gun cases where you'll have legislators say, okay, you can buy a stun gun, but we're going to test the limits of how much we can restrict it?
Well, I have already seen that in Hawaii. So on January 1st of this year, due to one of my lawsuits, stun guns and tasers legalized by the legislature, and they put in a new law that has background checks and a number of other restrictions of where you can purchase it. You have to purchase it either while you're on the mainland, the continental United States, or while from a licensed taser dealer, and they're required to give you at least some safety class. With it's honestly more restrictions in most states towards handguns, but they knew that they had to do it, and so they went right up to the limit of what they thought they could get away with. And right now in the Hawaii legislature, they're trying to pass a bill that puts in a number of sensitive places. That's areas where you can't carry.
For tasers and stun guns?
Correct.
Oh, wow.
And, that's something we're fighting right now. Thankfully, we managed to fight the first draft of the bill. And they were, and we're still fighting, and we're pretty confident we'll be able to kill the bill in total. But, it's they'd rather not have you carry in government buildings. That's a big sticking point that they're trying to get us with. But, right now people are carrying government buildings and there's absolutely no issues, and the police, no one's actually complaining. It's just simply a number of politicians. So, we're pushing back. And this isn't something you don't just win and get to go home and, rest on your laurels. I mean, I myself and several of my clients are very busy in the legislature right now trying to preserve what was accomplished with the Hawaii taser litigation. But, in other jurisdictions, and also in Michigan, they have a requirement that you get a CCW in order to get and go through the CCW training, which really just doesn't make sense, for the stun gun. And that's, that's just simply the nature of it. I mean, there's a lot of people that like to put in feel good measures just because it makes them feel better, and those aren't, and especially in the case of stun guns, I mean, I haven't seen anything that's particularly tied to any sort of real world, issue. It's, but, at the end of the day, though, I mean, they have to let you carry it. They have to let you, especially in Hawaii, they have to let you own it, and that's the court rules. So you're going to see a similar model when the Supreme Court issues. I guarantee you that you're going to see a rise in training requirements in good moral character stuff. I mean, trying to kick people out, just on small technicalities. I mean, the rumor is New York has actually hired many people in, to review people's records and just go through all the checks for new permit, because they know they're going to lose. So they want to be able to scour through people's applications. And, I think, I suspect a big part of that is you're going to be trying to find whatever that reason they can, other than not having a quote unquote good cause, to try and deny those permits.
Yeah, we don't know exactly what the Supreme Court's going to rule here, and we're going to be covering that closely at the Reload. But I think it's fair to assume that if they do throw out may issue, that this path that you just talked about here is what gun rights advocates are going to have to deal with in the aftermath of that. But you mentioned Hawaii there a couple times, and one of the other things I wanted to talk to you about is your litigation in Hawaii, because you are kind of the only person who's doing Hawaii gun rights litigation right now. And you've had some very well-known cases. You mentioned one, Young, which is probably what, if the average person listening would know you for, as if they know who you are from your litigation in Young, because you got a federal court to overturn Hawaii's ban on open carry before the Ninth Circuit reversed it, and now that's pending before the Supreme Court, as you mentioned. But you also have done a number of cases in Hawaii, which frankly, from my view, is one, Hawaii is the most has the strictest gun laws in the country. There's some competition in New York or California or New Jersey, but really Hawaii is kind of an outlier even beyond those states in a lot of ways. And two, doesn't really get a lot of attention. You don't hear a lot of people talk about Hawaii's gun laws, even in the gun rights community. And you don't see a lot of gun rights, groups filing suit on, Hawaiian laws. And so what is it in your mind that has made you want to pursue cases out of Hawaii, and why do you think it doesn't get the same sort of attention that cases that California's laws or New Jersey's laws get?
Well, Hawaii is where I'm originally licensed, and I have a number of family there, a lot of friends. I mean, I lived out there for quite a while, and the number one reason why I want to pursue it is because no one else wants to. I have friends and family there. That all have complained for a long time about the state of the firearms law, and the fact that the national groups are they focus their attention on some of the more the continental United States. So it's to me, I don't believe that an American state should be just simply completely out of a national conversation on a constitutional right. I mean, the Constitution applies to the whole United States, not just the continental United States. And so it's something that after McDonald, I noticed that everyone in all the May issue states were having CCW challenges and not Hawaii. So I decided, I was just going to pair up with a friend of mine, Richard Holcomb, to give Hawaii, to a degree, representation in the federal court system. And it's let's see. So I've just that's been about 11 years. So I've just and also a big thing is Hawaii has just such egregious laws.
Well, what are some of those laws that you've challenged, and especially some of the ones you've actually had success on? Because you've won some cases, right?
Well, yeah. So I'll give you guys a couple highlights. I think you guys will enjoy this. So Hawaii had a ban on green card holders, and it was one of two states post-Heller that had a ban on permanent residents owning firearms. So, and there was actually pushback. In 2014, I managed to get that law overturned. Afterwards, the city and county of Honolulu put in a restriction that said, well, okay, so green card holders are allowed to own them, but they have to go to their home country to get clearance in order that they're qualified under Hawaii law to own it. So my client happens to be from England. So we had sort of very, I thought it was sort of a humorous or ridiculous, I think is a better word, situation where someone that's from England, where we fought the Revolutionary War from, had to get permission from England in order to own a firearm in the United States. So that restriction went away after we filed a federal court action. We actually went to the Ninth Circuit, prevailed on attorney's fees on that because they weren't really too pleased about paying us afterwards. But and then after that was over, there was remaining pushback. They kept a ban on American Samoans, people specifically who had been born on the island of American Samoa, from owning firearms because they were neither an alien nor a citizen. So I had a client, he served in the Air National Guard, lived in Utah for a time, moved to Hawaii for work, and they said, you can't own a firearm. And it was like, how's this possible? I mean, this is a race-based restriction, effectively. People from other countries and people from the continental United States can own them, but only people that are American Samoan are not allowed to own firearms. And so I went to court, and I just, I felt pretty strongly about that. This is basically the last race-based restriction on firearms in the country. And thankfully, we won on that issue, and we've gotten rid of the ban on American Samoans. Two others that I've won on is last year, Hawaii law prohibits you if you've been convicted for a crime of violence. However, there's a very specific, that means something under the law. It's both the city and county of Honolulu and the county of Hawaii decided that they were going to go somewhat beyond what that definition is. So I had a guy in the Big Island of Hawaii, it's the county of Hawaii, who all he did was he yelled at his neighbor. And then his neighbor started yelling at him. The police showed up because of a third neighbor's noise complaint. They just wanted, them to turn down the noise. Police ended up arresting my client for a disorderly conduct. And again, all he did was get into an argument with another person over a fence, mind you. And they said, this is a crime of violence. You can never own a gun again.
Wow.
And, so we filed a federal lawsuit on his behalf. And thankfully, we've gotten, they agreed to an injunction after the court made it very clear that they didn't have a chance there. And so we prevailed. So they've gotten rid of that policy where basically any crime of disorderly conduct is, they were just prohibiting people for life. Including yelling at a person. So we had two other clients in the city and county of Honolulu. They had a similar situation. They had agreed to tickets. It's called an infraction. It's legally in Hawaii, it's the same as getting a speeding ticket. And they agreed to these infractions specifically so they could keep their gun rights, and along with another, they pay a $50 ticket, it's done. That's life. Well, the city and county said, no, those are crime of violences. Well, that's legally not even a crime under Hawaii law. And they were saying lifetime ban. So one of my clients, he lost his job as a security guard, where he had to carry a firearm. He'd taken a huge financial cut, having switched jobs. And he, another of my clients, he lost his firearms rights, again, just for a ticket. He was... And we filed a lawsuit for both of them, and thankfully we were able to get another stipulated injunction for those two gentlemen.
And
So,
didn't one of your most recent cases lead to a new law being considered in Hawaii as well right now?
Yes, so right now, in a few years ago, we challenged 4 different registration issues. 2 of them were with the county, 2 of them with the state, and that's called Yukitaki v. Connors. And we were able to settle with the city. And in the permit process in Hawaii is very it is very egregious. You have to. It's basically it's a 3 trips to the police department. You have to go apply for the permit to acquire, wait 14 days, and then you have to physically come back to pick up the permit, and then go pick up the firearm, then physically come back with the firearm to be registered and inspected.
Right.
So
and that's just to own a gun, right?
Yeah, that's
just to own a handgun, which obviously is wildly different from, say, Virginia or most other states where you can buy a gun, you pass the federal background check, and you walk out same day.
If it's your first gun, you also have to take a training class. So with the city, we had just a few points. I mean, this is the way they've been doing things since 1934. And why not email the permit to the person who wants to purchase the firearm, rather than make them wait? Remember, the police station's only open a few hours a day during working hours. So if you want to buy a gun, you have to take the firearm, take a day off work to go do this firearms process. So, so when they say you have to come to the station to pick up the permit, what they're really saying is you need to take at least half a day off work. So we were like, why can't you just email it? And, under threat of a federal lawsuit, okay, we'll put in we'll start emailing it. And we also got them 1 day a week to extend the hours past the working period. So I think it used to be 4 o'clock, I want to say, and now they're open on Wednesdays till 7:45. And they agreed to stay open as late as you have to be in line by 7:45, and they'll serve you. So sometimes they're there till like 9.
Yeah.
But that's what we settled with the city, and that's permanent. That's through settlement. The 2 things that we got against the state is they, the part where you have to register the gun at the police station. I have a photo that I submitted to the court where there's this giant line of people just waiting, to register their firearms first thing in the morning. It's, and unload. It's frankly, we explained to the court. I mean, if anything, it's frankly not all that safe. There was just a woman beaten in front of that same police station, and the police weren't able to stop it. Now you've got, 75 people, waiting in line with unloaded firearms. So what we did there is we got that law enjoined. That was state law. We got it enjoined. They had to go to the register it. They've replaced that with an online system.
Yeah.
So now instead of having to register the firearm, you can put the information into the online system. And that's already in place. It started on January 1st.
Yeah.
The second part of that was, in order to buy a handgun, you have to get the permit to acquire. And once it's issued to you, it's only valid for 10 days.
Right.
So in light of everything else, that's a real big time constraint. You're taking lots of time off work right away. But here's the kicker. The rifle permit is valid for a year. And so one of our arguments to the court is, hey, if everything's working just fine for these rifle permits that are a year, why can't you do the same with a handgun permit? And so the state appealed both those rulings up to the Ninth Circuit, and we're filing our answering brief in the next couple of weeks on that. That law was stayed. That part of the ruling was stayed, so that's going up on appeal right now. But the registration, that's already in place.
Yeah, but I think that all gives a pretty good insight into how much stricter Hawaii's gun laws are than even deep blue states like New Jersey or California. I mean, those are some pretty outlier pieces of regulation there in Hawaii, and there really is not much in the way of litigation beyond what you're doing. And I mean, even the Young case, the more famous case that has gone up through the Ninth Circuit and is now pending before the Supreme Court. I mean, you showed in that case that Hawaii does technically they have may issue for open and concealed carry, right? But they have never issued a single permit.
The county of Hawaii has never issued a firearms permit.
Yeah, so that I think that gives people an idea of just what is going on in Hawaii and why it's so surprising to me, at least, that there isn't more attention paid to it. I've written about it myself quite a bit, and about the suits that you've done. I've interviewed Young himself and so forth, but you really don't see a lot of attention paid to this, and you don't see a lot of activism on the parts of big gun rights groups. So, I mean, if people want to help these litigation, or they're hoping to see something happen, I mean, they really is just kind of you.
Yeah, I mean, something that this is honestly getting some traction in the courts has been of great personal satisfaction. I mean, I did the stun gun litigation nationally on a $10,000 budget. I was, so the theory, and that's just paying for costs, the filing fees, the plane flights out to, say, New York.
It's incredible.
That's certainly not paying me anything. But I, was able to do that. And my theory through this, I was going to either win and be able to pull this off, or I was going to lose and I'd run out of money in my budget to be able to go further. And, it's so I was, and the same. I think the big thing with my work out in Hawaii is it's not supported by any of the national groups. Thankfully, my good friend Stephen Stablia has been willing to help me out with it, and and most recently Kevin O'Grady has a couple of people basically effectively volunteer their time. And that's the.
I think if people want to, people should pay attention to what's going on in Hawaii, and if they want to know what's happening there with the gun laws and gun litigation, I mean, they're going to have to pay attention to what you're doing, frankly. So, we'll have to have you back on the podcast again soon in the future to talk a little bit more about some of these cases. And what you've been doing. I know you also have a bump stock case that we don't have time to get to, but you're doing quite a bit of litigation. So I'm glad you're able to come on, talk about the stun gun cases and how that all has gone, and then talk about Hawaii and some of these outlier laws that they have and the litigation that you've been in against them. So we really appreciate you being here, and hope to have you back on soon.
Hey, thank you for having me, Stephen.
All right, now it's time for the weekly news update. I'm here with Reload founder Steve Gutowski. How are you today, Steve?
I'm doing good. How are you, Jake?
I'm doing well. Always
our contributing writer.
That's right. Always happy to be on the podcast and talking to the readers and listeners. You had a big story today, big new development in the permitless carry frontier. A new state just became a permitless carry state. Is that right?
Yeah, Ohio. Just adopted permitless carry. Governor DeWine signed it into law, and now they're the 23rd state to adopt the policy. And I think we're on the road now to 25 soon. Georgia and Indiana might be coming up here soon, really within the next month or so, because their legislative sessions are going on as well. But yeah, the governor signed the bill. He didn't put out any statement. His office told me they didn't have any further comment on it, so I guess he's not making it a big deal out of it. But obviously, a lot of gun rights activists certainly are. This is the policy. It's often called constitutional carry by gun rights advocates, of course, and it allows anyone over the age of 21 who can legally own a gun to legally carry it on them, concealed without a permit. And now you've seen this become the most popular gun carry regulation in the country. It's passed shall issue, where where there's still a permit, but if you go through the process, you are entitled to receive the permit. They shall issue it to you. They can't decide not to if you pass the background check and complete the training. That's I believe that's 20 states now, because the permitless carry is chipping away at the what used to be shall issue states. And then you had may issue, right, which is the policy that's being challenged at the Supreme Court right now out of New York, which says that if you can go through those same steps of obtaining the required training and passing the background check, but you also have to prove you have a good need to carry a gun, which generally means that in the end it's up to the government official as to whether or not they want to issue you a permit. They may issue you one, but they do not have to. And generally that means that most people are not eligible for concealed carry permits in may issue states. Only people who can prove they have a special need beyond regular self-defense. So we're seeing that's probably going to be wiped out by the Supreme Court. We'll see how they rule. We've talked a lot about this in the past, but now you're seeing, without any court rulings, permitless carry become more and more popular, right? I mean, you actually, Jake, you had a really good analysis piece about how far things have come, right?
Yeah, that's right. As you pointed out, it's a pretty big deal that now permitless carry is the most common carry regime in the country. It surpassed shall issue, as you said, because just less than 40 years ago, you say 1986, that's the year before Florida adopted the shall issue carry regime that kind of spurred the nation to gradually over time fall in line, and virtually almost every state, minus those few holdouts that retained may issue, adopted that policy. But back then there was just one state with permitless carry, and that was Vermont, which has had the policy since its founding. That's why it used to be kind of called by a nickname, Vermont carry,
right?
The policy, because that was just the only state that had that option. And at the time there were only 8 shall issue states, so it wasn't particularly common to have a pretty liberal carry regime. And now, the year 2022, you've got 23 states that have permitless carry. I think you said 20, either 19 or 20 shall issue, and those remaining 8 may issue states that could very well, at any moment when the Supreme Court rules, could become shall issue. So it's been a big transition in just a generation.
Yeah, and even DC now is shall issue,
right?
After their total ban on concealed carry was struck down by a federal judge, and then later on their may issue law was also struck down just a couple of years later, and so now their shall issue. I think you're poised to see shall issue be the floor across the country, and then permitless carry will probably be the preferred policy of every red state, I would say. Every
right.
state that has the triple red, the House, the Senate, and the governor, all controlled by Republicans. It's hard to imagine a future where all of those states don't eventually move to permitless carry, and probably within the next year or two. I mean, there's only a couple holdouts left, really. I think
Sure.
that's what, well, there's Georgia and Indiana, which are considering it right now, and might have it in law by the end of this month or maybe next month. Then you've got Florida, which you've had Ron DeSantis, the governor there, has expressed support for it, although I think it hasn't made any significant progress in the legislature this year.
Yeah.
But and then you have South Carolina, I think Nebraska, and
Right.
so you're even if those states don't get to it this year, it's going to become increasingly difficult to avoid that pressure if you're the last red state that doesn't have permitless carry, right?
Yeah, I think that's exactly right. And I think Ohio in this case is actually a pretty big indicator for that kind of trend, because as you said, Ohio is a triple red state, but it's not super red. It elects Democrats, and for a long time it was considered a swing state. And Governor Mike DeWine, while he did sign the bill, has kind of been straddling the fence on the gun issue in the past. He's voiced support for some gun control policies in the past, especially after that Dayton mass shooting a couple years ago. He was open to expanding background checks and that sort of thing. So the fact that such a policy can pass in a state like that, which is now the second most populous state behind Texas to have this policy, I think it's a big deal, a big indicator, and I think it will cause other red states to kind of fall in line because they don't have the same impediments that a state like Ohio does.
Yeah, absolutely. And it's interesting too because the policy doesn't poll that well. I think you see limited support for this when you get polling questions that ask about it. But
Sure.
it's one of those issues where it seems perhaps the people who do care about it are very passionate about it, and the people who might say they don't prefer it on a polling question just aren't that interested or aren't that concerned about it unless it leads to like observable negative outcomes that can reasonably be blamed on the policy, which I don't think we've really seen that yet. I haven't seen a politician get recalled because they voted for permitless carry anywhere,
Sure.
right? Like that's not something that's really happened. I don't even think you've seen like a concerted effort to do something like that. Obviously, you have a lot of people who are organized against these policies. The gun control groups universally are opposed to permitless carry. You had, I believe, for Ohio, you had this is Christine Woodworth, who's a volunteer for the Ohio chapter of Moms Demand Action. This was put out by, Moms Demand Action was part of Everytown. She said, today Governor DeWine sided with the gun lobby over public safety, over the safety of Ohio's law enforcement officers who work every day to protect our community. Our state has some of the weakest gun laws in the country, and today we lost one of the last foundational public safety measures on the books for no reason other than to satisfy the gun lobby. So that's how you'll hear them talk about this policy. But I don't know that that's led to any sort of significant action against those who've voted in favor of it. Now, to be fair, this has been an extremely quick rise to prominence for permitless carry, as your piece laid out. So maybe a backlash will come at some point if people, associate rising, murder rates with these policies. But to this point, that certainly hasn't happened, and I'm not sure it's going to, right?
Right. Yeah, it's possible, but I'm with you. I'm not sure it's going to happen. I think the good example of that is a state like Vermont, who has had it since its founding, but it's also been a deep blue state for for almost forever now, and you haven't seen any effort to get rid of that policy there. And likewise, any of the other states that have adopted permitless carry, which obviously are much more recent in the grand scheme of things, but there hasn't been any repeal of the policy in any state that has passed it. So while there is upfront opposition from gun control groups, sometimes law enforcement groups, you never really see the permitless carry policy get repealed. So
that's a great point.
I don't know if it'll happen in the future.
That's a very good point. You haven't seen any states move from permitless in the other direction ever. So
right.
We'll keep an eye on this and see where it ends up, of course, over at the Reload. So make sure you guys are subscribed to our newsletter or become a member today so you can read the analysis that Jake wrote. But we're actually going to go over and talk to a member now in one of our member segments, one of my favorite kinds of segments that we do for the podcast. So we're going to head on over there right now. All right, I'm here with Reload member Nathan Gorenstein, who's we're doing another member segment, one of my favorite segments. Nathan, thank you so much for coming on and telling us a little bit about yourself. Why don't you give us a little bit of background about who you are and how you got into firearms?
Well, my career was spent as a newspaper reporter and editor at the Philadelphia Inquirer, which I left about 2012 to write books. And my second book is a biography, social history of John Moses Browning and his times.
Ooh. And
I chose that because I realized there had never been a serious biography of his impact on the world. I got into it in a roundabout way. I was actually looking into single action army revolvers for another whole project. And so I went down an internet rabbit hole and I ended up at John Browning. And I thought, there hasn't been a book, I should write one. But in the meantime, I got into shooting. I've always been mechanically inclined. I've used to do fixed cars when I was a kid, and I still built some furniture and rebuilt a boat or two. And so when firearms came along, it was an interesting mechanical concept that I hadn't dealt with before. And that was the thing that initially attracted me to a book topic. But I got into guns and I started shooting. And I actually wrote a piece for the Inquirer after I had left about why gun control was doomed to failure. And I said the secret that folks don't know is that shooting guns is an enjoyable sport.
Right.
It's fun. And it's a challenge. I've certainly found it to be that way. The mental, I mean, I shoot USPSA and SEAL Challenge, and I do a little rifle. And, you know, the thing that's most interesting to me, in competitive terms, because it's the competition situation that makes the challenge, is it's all in your head. It's all being able to do a lot of things very linearly in a straight line very quickly, which is also very unlike writing a book, as you probably know from writing articles,
Yes.
which is a sort of a circular thing, right?
Absolutely.
You know, you know what you know, and you try and figure out how to do it. But with, you know, doing a stage in a firearm competition, you have to think things, you have to do things in a very particular order, repeatedly, very quickly, and that was a real mental challenge for me.
Yeah. I mean, I think that's shared by a lot of people. But I want to zero in for a second on the mechanical aspect, because I think that's something
Sure.
that is undercovered or not talked about a lot when it comes to why firearms are popular with people. There's all kinds of reasons that all kinds of different people get into firearms, but one of them is the mechanical aspect, and that's something that I also have found extremely interesting in my time. I mean, this AR behind me here for everyone watching on YouTube, I built that AR. I built a number of ARs. You know, even just the regular maintenance of a gun requires some sort of mechanical interaction with it and understanding how it works and being able to take it apart to clean it and lube it. But, I think that's something that is really not talked about at all, especially outside of the gun owning community, as to why this is captivating to a lot of people.
I think it's a big reason why people get into it. It's the they're little machines, and civilization is based on machines. And when I purchased a single action army from Roberti. And first thing I did was take it apart. And as I got into Browning's history, I became fascinated about how these machines worked and why they were different from other gun manufacturers. And I had always liked working with my hands, so I started buying firearms in part to learn how they worked. And I've ended up I did a couple of 80% 1911s, and I've done a 2011 that I shoot with now. I even actually fit the barrel, and it's accurate. Damn. And so all that gave me an understanding for how these things work and appreciation for Browning's genius. But it's, why is it similar to the attraction that woodworking, for example, has for me? I think in part because it's very finite. If you make a piece of furniture, you know whether all the joints fit, you know whether the finish is good. There's no ifs, ands, or buts. It's there. And the same thing with building a firearm or shooting a firearm or working on a firearm or reloading ammunition. There's a little gray area sometimes with ammunition, but whether a firearm works or not is pretty clear. It does or it doesn't. And if it doesn't, there's specific things you look at to try and figure out why. And it's an inventive, and it involves the mechanical skills, and humans have always been into the mechanical skills. And there's also probably the challenge of doing something that candidly is a bit dangerous. You have to be careful, and you have to pay attention. And I guess mastering that is also a thing that attracts people to firearms too.
Yeah, that makes a lot of sense. For me, it's very similar to working on my car. Working on my Jeep. It's the same sort of enjoyment that I get out of that, or frustration. Depending on how the project goes, I suppose. But
Yes.
But yeah, Browning in particular is such an interesting figure, especially to people who are into the hobby of collecting firearms, because he was so prolific and so influential in the course of American gun design, in the modern era. Like, I mean, I got one of his guns right here. This is a 1911, right? Everybody knows the 1911 in the gun community. Even outside the gun community, this was the sidearm for the Army for 80 years or so. And in fact, even though Browning was doing most of his important work at the sort of turn of the 20th century, a lot of his gun designs are still popular, and some are still employed in the military today. The Ma Deuce 50 caliber machine gun is still used.
Yeah, well, the modern handgun is based on Browning's work. The book was a lot of fun to do, and I was lucky because his last surviving grandson, Bruce Browning, who has unfortunately since passed away, wanted a book done at the same time that I wanted a book. So I ended up in Utah one day, and Bruce was kind enough to sit with me for 2 mornings and do interviews. He was in his 90s. Physically, he was struggling, but mentally he was great. And he was really very helpful in telling me some family information and getting the access that his sister had, who was also helpful, Judy Browning Jones, to 40 boxes of family records that no one had seen in a century. And that was crucial because it gave me a lot of data and information that was previously unknown, and changed a lot of the stories about Browning that were partially folklore, partially accurate. And
can you give us an example of one?
Yeah, the biggest thing is probably how he split up with Winchester. The famous story of Winchester is that they wouldn't pay him royalties, so he took his shotgun and hopped a boat to France. To Belgium, to FN. It's not quite what happened. He had actually already was working with FN on his pistols. He had been over there a number of times. It wasn't his first trip. He had told FN that they could have this automatic shotgun he was making. But most importantly, what I found was a contract for royalties signed by Colt and signed by the Brownings. So that whole story that they wouldn't pay him royalties wasn't the case. What had happened was that he and Bennett, who was the guy that ran Colt, sort of had a falling out. Matt wasn't a fan of him. Bennett wasn't a fan of Matt, John's brother. And when Bennett, for a variety of reasons, didn't want to make what became the Auto 5, Browning angrily said, well, I'm going to force his hand. I'm going to go in and ask for more money than he'll ever pay me. And then he'll say no, and I'll take the gun and I'll bring it to FN. And this is in a manuscript written by his son that has never been published before, never seen before, wow. This account. And this was one of the documents that was in the 40 boxes that Bruce Browning gave me. I have a copy of the royalty contract from 1899, and I have this manuscript by his son that was written late in his son's life in the 1950s. So it's a whole different story. And there's even a joke at the end. They walk out of Bennett's office, and Matt never gets a word in edgewise. It's sort of this taciturn conversation between Bennett and Browning. Browning gets his prize. Bennett says no. Then Browning says, "Okay, we'll leave." And Matt says, "I never got a word in." And Browning says to his brother, "Well, you can go back." And he starts laughing. The brother does. And I don't want to go back. And he makes a comment that summarizes sort of the problem with the relationship, which is that, he just thinks we're a bunch of hick country boys, mountain men from out west. And in that comment, you sort of get a sense of, whoa, this was the whole underlying the relationship. Here was Bennett, who was this Yale graduate, or Princeton Yale graduate, who had been an officer in the Civil War. And here are these two guys from Utah who actually had to teach themselves how to speak correct English when they started going east. They used to, another family story, they bought a grammar book, and on the train rides east, they would teach each other how to speak correctly, how to spell, because they had left school. Browning, I think he left when he was 12 or 13. And so they were obviously very smart guys, yeah. and they taught themselves. But they always had this sort of, obviously, a rocky relationship with the Winchester people.
That's fascinating. I mean, it's incredible what he was able to accomplish, obviously, in his lifetime of gun design and how much influence he had.
Now, Winchester gave away the pistols to Colt, and Bennett got a lot of grief from that, from his dealers, because obviously the pistols were very success. Bennett was a very conservative guy and sort of wanted to do shotguns.
Yeah.
Yeah. So
I mean, I bet there's a lot. It sounds like there's quite a lot of undiscovered history in this book that people
there is, if I
would probably be
so
interested in reading.
Yeah, I'll hold it up. You can see it.
Yeah.
It's The Guns of John Moses Browning. You can get an Audible or Kindle or paper, or not paper yet. It's still in hardcover.
Okay, so that people can go to Amazon if they want to check out the book.
Sure can.
And
Amazon, Audible.
I'm particularly interested in it, honestly, so I think I'll probably read it as well. So how did you become a Reload member? Because this is not an ad or anything. It just happens to be something that you do and you're a Reload member.
Yeah. So I'm interested in firearms news, and there's a lot of sites, some better than others, some political, some not political. But I was looking, but not sort of. I'm an ex-newspaper person, so I'm looking for something that has a sort of that ethic. Yes, we believe this to be true, and we've gone back to the sources. And I was looking for, I don't remember the article, but I came across something you wrote, and I said, this is what I've been looking for. Someone who can cover the business and the industry, and do it in a sort of a neutral, objective, or fact-based manner, and which is why I joined up.
Thank you.
Yep. So congratulations for doing it. It's a tough thing you're doing.
Yeah, it's
to try and start,
not easy.
To try and start a media company is not the road to riches.
No, certainly not. Although thankfully it has gotten, the barrier of entry, I think, has gotten lower, which is why something like the Reload can exist these days. But hey, we appreciate you coming on and talking a little bit about your background and what you're up to. And I think if people are like what they heard about the book, they should go and check it out. I mean, John Moses Browning, he's a legendary figure in American gun history for sure.
Yeah, it's a great read too, if I can say in all modesty. It's easy. It's a quick book to read and very entertaining.
Absolutely. All right. Well, that's
the people.
No, go ahead.
No, that's fine. No, I was going to say those are the reviews on Amazon, so you can read those, and it's not just my opinion.
There you go. And maybe we'll do an excerpt for the Reload. If that makes sense, because
sure,
I think people at the Reload would be interested in this. John Moses Browning is a fascinating figure, and like you said, there's not as much out there on him as there probably should be. So I think our readers would be interested.
Thanks for the interview.
Yeah, thanks for coming on. That's it for this week's episode of the Weekly Reload podcast. If you are interested in becoming a member yourself, you can head on over to thereload.com. We got monthly memberships, yearly memberships. We even got a lifetime membership if you want to take the extra step to help support the publication, which is completely member funded. And you'll get access to dozens of exclusive pieces of reporting and analysis that you can't find literally anywhere else. And you'll also have the opportunity to get this podcast a day early and come on the show if you want to. So until next week, we'll talk to you guys later.